So we're going to continue. We said last time we were on page 156 of the Practice of Universal Ethics. That's part 2, chapter 6, page 156. And then I think we did get to the top of 157 as well. Discussed that there are two, again, we reviewed the two approaches to the 7 laws, one that is more strict and adopts all the detail of Jewish law, and one that is less strict, but yet at the same time, there is a certain minimum in which many of the laws in Judaism that are not affirmatively part of the 7, however, to act in a way that is contrary to the teachings of those laws would be a violation of the Noahide law. In other words, what I mean to say is that, let me give an example here, that among the 613 commandments, there are many specific prohibitions on judges. So according to the first approach, that Noahide law basically goes it alone and doesn't follow other specific precepts of Judaism. So, meaning to say, it doesn't incorporate the other commandments that may be associated with that particular command of 7. Nevertheless, you cannot act in a way that it corrupts or it negates those laws. In other words, there are many specific affirmative commandments that direct the way a Jewish judge has to behave, an Israelite judge has to behave, right? So according to the first approach, the 7th law of Noah that directs the institution of courts doesn't incorporate all the laws that instruct how a judge has to behave. However, if a judge acts in a way that is antithetical to the Jewish approach to law, for example, acts in a way of the courts of Sodom, then he violates that Noahide commandment. So take a look, and this is clearly stated by our Rabbi Schneerson. If you look at footnote 49 on page 157, it says, as quoted in the chapter on justice, Rabbi Menachem M. Schneerson writes, in regard to the obligation of dinim, which means the institution of courts, even though in the obligation to appoint judges, there are not included specific laws as to how judgment should proceed. Nevertheless, it is understood that if they proceed in judgment like the judges of Sodom, they transgress the mitzvah of dinim. They transgress the mitzvah of appointing judges. You follow? So in other words, what we're saying is, again, based on collectively on this idea that the 7 laws proceed rationally, and based on the ideas that we have to examine those laws and understand their spirit and what they represent and what their instruction is and what kind of a society these 7 laws want the nations to build, that leaves us in a situation in which there's an obligation not to negate, not to behave in a way that goes against the type of values that are set down in Torah in relation to the courts for the Jewish people. So in other words, if the courts for the Jewish people say you shouldn't take a bribe, so here's the interesting distinction. So is courts of Israel not allowed to take a bribe, even in other words, they're not allowed to take payment from one of the litigants, even if it doesn't affect their outcome. However, according to this approach, that the 7 laws don't incorporate all Jewish law, it would be feasible to say that a non-Jewish court would be permitted to take that, I guess, literally a bribe, but let's just say money from a litigant, as long as that doesn't affect the outcome. Okay? So obviously taking money to come to a corrupt outcome is forbidden because it goes against the very spirit of everything that creating the court stands for. However, taking money and then still having an upright judgment might not, because even though it's kind of coming close to corruption, it's not corruption, or maybe has an appearance of some type of corruption, but in the end, the result was fair. So it doesn't really matter. So that's one example of the distinction between Jewish law and the first approach, that Noahide law does not incorporate all the Jewish commandments that are related to that specific Noahide law. Let's see the bottom paragraph on 157. The standpoint of the second view: all socially rational interpersonal commandments from amongst the 613 other commandments are included in Noahide law in the category of law for the maintenance of society, which basically means the seventh rule, which is it's included in establishment of courts, because that law would be understood for any law that creates the maintenance of civil society. So it wouldn't be limited to appointing judges, it would be limited to basically, in other words, the administration of a civil and just society. So any law between a man and his friends that's among the 613 would be included in Noahide law according to the second view. So again, so this brings us to the idea of Torah study, that according to the second approach, there's a tremendous corpus of Jewish law, classical Jewish law, that a person can actually study, completely kosher and in a form that's puts a person of the nations on the level of a high priest. As we said before, I quoted the Talmud in the past, Rabbi Meir's statement that a ben Noach who occupies himself with Torah is deemed to be like a high priest. And the Talmud asks, but a non-Jew is not supposed to study Torah. The Talmud answers, yeah, but not regarding their own laws. Their own laws they can study, and not only can they study, but they're considered like a high priest. So the point is, this broadens the laws that a ben Noach can study to the entire corpus of civil Jewish law, which is very large, by the way. A lot of the Babylonian Talmud discusses this. So you have, in fact, most of yeshiva study revolves around the study of the civil law because it's quite complex. And a lot of it is quite conceptual, and the rabbis and the yeshivas like to talk about it because it's very deep and conceptualized and difficult. But anyway, so the several tractates, famously the three Bavas, Bava Kama, Bava Metzia, and Bava Basra, the three gates of Nezikin, of the study of tort law, but it's not just torts, it includes lost objects, it includes all types of different litigation disputes in civil law, theft, robbery, I said finders, guardians, a lot of other things, including real estate law, inheritance. There's a ton of things that it discusses, hundreds and hundreds of pages that this seems to open up for study. Without a point even to the most strict interpretations of the limitations of study. This is all open, all fair game, as we say. Okay. Whether these are, I'm continuing now, page 157 in the middle of the paragraph. Whether these are subsumed under the Noahide law of theft and material harm or of justice, they would appear to be obligatory also in their detail in Noahide law, according to the second view. So if you look at footnote 15, it says that the view that all the interpersonal commandments between man and man are incorporated within Noahide law for the maintenance of a civil society, it says in footnote 50, this is the view of the Rambam, as elucidated in Likutei Sichos, volume 5, pages 158-59. So it's Maimonides' view that this entire corpus is included in the maintenance of civil society, basically dinim, appointing judges. Okay. Footnote 51. There is a suggestion in the Kutei Sichos, which is again a collection of the Lubavitcher Rebbe's talks, on the pages 158, 160, and footnote 67. What does he say? That honoring parents, based on the rationality of repayment of a debt of gratitude, and charity as a requisite for interpersonal relationships in an orderly society, might both fall within the category of civil law, the maintenance of a civil society, in other words, according to the Ramban, according to Nachmanides. The definitive source for regarding charity as an obligation, similar to the Jewish command of charity, however, is found in Rabbeinu Nisim, set out in chapter 7 under the heading of charity. The source for acquiring the honor of parents in a manner similar to the Jewish command of honoring parents is located by the Sefer Mitzvos Hashem in the precept of respect for God. It's documented in chapter 3 on the reverence of God. See there. Okay, let's stop there as far as that footnote. Let's go back to our study. Okay, now we're going to turn to page 158. The exception is where the tradition explicitly exempts Noahide law from certain details of these precepts from the 613 commandments. So if the tradition particularly says that non-Jews are exempt from something, then they're exempt. With regard to laws amongst the 613 commandments between the person and God, which do not overlap with the 7 Noahide laws, where these have directly rational aspect, they're also binding on humanity. So now remember, those of you who haven't, have joined me recently may not be aware of this, but generally, Jewish commandments, Torah commandments, are split up into 2 categories: laws between man and God, and laws between man and man, interpersonal commandments. So we just said on the previous page that interpersonal, basically, according to the second view, are completely incorporated in Noahide law. Now the question comes up now, what about laws between man and God? So here's where he's saying, well, if there's a rational basis, then they're subsumed. So he explains, but actually he's now addressing this question to both approaches. And he says, according to the first view, such laws would have to be kept at least negatively, just like rational interpersonal laws, and presumably also according to the second view. So in other words, according to, if they're rational, in other words, for example, all ways of honoring God that makes sense has to do with a person's obligation to have gratitude for God and everything that he's given us, like a parent. And in that case, it would be applicable to non-Jews as well. So this is what he says. He says, well, not so fast. According to the first view, it wouldn't be applicable in its detail. However, you wouldn't be permitted to do something that is an antithesis to that idea. So in other words, the point is, if a Jew would be obligated to honor God in a certain way, a non-Jew would be obligated at least not to dishonor God in an extreme way. Again, we're talking here about baseline, by the way. We're not saying what a non-Jew is permitted to do voluntarily. We're talking about obligations. I want to make that clear. And right now, we're just talking about what's obligatory on the nations, not what they can do. Obviously, you can add a lot of things, but what we're talking about is simply how far does the obligation go? Okay, so what we're saying is, according to the first view, that the 7 laws go their own way. So then when it comes to anything that wasn't directly included in the 7 laws of Noah regards to his a person's relationship with God, person at least should not dishonor God in a way that's the antithesis to the Jewish idea. obviously idolatry is clearly the antithesis, but it seems to me that, for example, connected to this would be different, the question is, would things like resorting to soothsayers and magic be included according to the first view? According to the second view, there's no question that all those different laws that were given to the Jewish people are also included in the seven, that non-Jews shouldn't resort to magic and so on and so forth. And those of you who were with me for my classes in the work of Path of the Righteous Gentile may recall that he mentions all those prohibitions relating to magic and the prohibition against practicing magic and going to magicians and soothsayers. They're all included by Rabbi Chlorphene as prohibited to the Noahide community as well. But I think those might be an example of something in antithesis to honoring God, because basically the person's turning towards other means and turning towards the help of negative forces to help him instead of turning to God. So in other words, according to this approach, there may not be an obligation to pray to God, but on the other hand, you wouldn't be allowed to turn to other powers and seek their help. But however, according to the second approach, and maybe even according to this first approach, there would be a minimum obligation to just to pray, because God is the only one that, just a recognition and a proper respect towards God as being the source of blessing, to turn to him when we need help. And so that might even apply according to everybody. For example, as he continues here, it says, an example of this is the concept of prayer, which rationally follows from the concept of a creator who is able to sustain and benefit his creatures and to whom we should turn for our needs. So not how and when one should pray is prescribed, but rather that one should not disregard and neglect prayer. And this is left to group and individual practice. So now the question is, this statement that he makes here at the end of section C, what we just read, where he says that the Noach is obligated to pray, but at his own, not at any set time, not at any set literature or anything like that. According to that, is that according to the first approach or the second approach? It's not so clear. In other words, my question is, according to the second approach, that if there's a commandment on the non-Jew, then we incorporate Jewish law. So why don't we incorporate Jewish law about prayer? It's a little unclear. Another thing we see from this, that if a non-Jew prays whenever he needs to, that's not considered making your own religion, because he's not following Jewish prayer practice. There's no obligation to follow Jewish prayer practice, and it's not going to be deemed making your own religion. Particularly, I think what they're saying is people come together to pray when they have different needs. It seems like even if they were to come together on a daily basis and people would just have moments of silence and everybody would be praying, doesn't have to be in necessarily the Jewish framework. Any questions so far?